contract and doctrine for substantial performances. Number 4, we will identify the ethical dilemmas that business manager face in the context of good faith performances. Number 5, we will discuss some events of this chart. Some events of this chart through mutual consent and through an operation of law. Number 6, we will recognize the certain event that result in a breach of contract, and I will explain the doctrine of anticipatory litigation or doctrine of anticipatory breach. Number 7, we will discuss the appropriate remedy, appropriate compensation that is available to non-breaching party, available to damaged party, injured party, to the plaintiff. Number 8, we will discuss the responsibilities of an injured party to mitigate the damages. Plaintiff's duty to mitigate the damage, to decrease the damage that is complying with the stringent doctrine and tender performance doctrine. Number 9, we will discuss the right of third parties in a contract. Those rights are assignment rights, delegation, and third party beneficiary. Overview of this chapter. This chapter continues to discuss the contract by focusing on the issues that is related to the contract performances. The issues include the concept of conditions, how the two parties allocate risk through the three types of conditions, and the issues covers requirements to meet the standard of good faith performance and standard of substantial performance. And this issue focus on some event that discharge a party from having to perform from the contract performances. This chapter also deals with the consequences of failing to perform as promised. failing to perform is known as a breach of contract. Failing to perform is referred as a breach of contract. And this chapter covers a lot of remedies, a lot of compensations that is available to the damaged party, available to the injured party after the breach of the contract. This chapter also covers the right and duty of the parties when a contract is assigned to the third party, when a contract is delegated to the third party. Also, this chapter covers the right of third parties beneficial to the contract, so third parties beneficiaries. Legal right. Once all of four elements fall into contract, four elements: agreement, consideration, legal capacity, and legality, then the parties, two parties, are legally obligated to perform the contractual duty. Duty to perform is a final process of the contract. Conditions in a contract. Some duties are unconditional duty or absolute duty. Unconditional duty or absolute duty is a duty to perform, does not depend on, does not condition on any future event, is an absolute duty, unconditional duty. However, conditional duty is the duty to perform depends on, conditioned on the occurrence or non-occurrence of a future event, is a conditional duty. Two types of condition: absolute non-conditional duty. Two types of duty: unconditional duty or conditional duty. When a party's duty is unconditional, he has a duty to perform perfectly unless the performance is excused by the operation of law and by the mutual consent. When a party's duty is unconditional and the duty is not excused, the failure to perform is referred as a breach of a contract. Okay? Failure to perform constitute a breach of a contract. concept of conditions. Sometimes from a source, a duty to perform is conditioned. Depends on the occurrence of some event. Example, I will contract to buy your house on the condition that I am able to obtain the adequate mortgage financing, mortgage loan. Conditions must be fulfilled before performance is required. If the conditions is not satisfied, the obligations of the parties are discharged. Avoid types of conditions. There are 3 types of conditions. Condition precedent, condition subsequent, condition concurrent. 3 types of conditions are existing in a contract. Condition precedent is an event that must be occurred before the contract performance is a condition precedent. Condition subsequent excuse the contractual performance. Condition subsequent discharge the contractual performance if a future subsequent event takes place. Third type of condition is a condition concurrent. Condition concurrent means the 2 parties must perform the duty simultaneously, perform the duty at the same time. Okay, condition precedent. Condition precedent is a future uncertain event. That event will be creating a duty, creating an obligation to perform for the one party. Is a conditional precedent. If the condition, future condition does not occur, then the contract performance does not become due. If the condition does occur, then the duty to perform the contract will be raised. Example of condition precedent. Mr. Kim contract to buy a house on the condition that Mr. Kim is able to obtain the adequate mortgage financing. The contract will be raised, and Mr. Kim is obligated to purchase the house once he obtains the mortgage loan from the bank. Obtain the mortgage loan from the bank is an example of condition precedent. Second type of condition is a condition subsequent. Condition subsequent is a future uncertain event that discharge the duty to perform. Future event will discharge my duty to perform the contract. When a duty is subject to a condition subsequent, the duty to perform a right. But duty to perform will be discharged if the future event, uncertain event occur, then my duty will be discharged. Example, Mr. Kim agrees to work for Ulco Company until he returns to the college at the beginning of fall semester. Mr. Kim returns to the college in August in the fall semester. In that cases, Mr. Kim can discharge his obligation to work for Ulco Company under the contract. It means that Mr. Kim will not have a duty to work for Ulco Company, and he returns back to the college, and his only job is to study. So, type of condition is a condition concurrent. Condition concurrent means that the contract request for two parties, for the both parties to perform their obligations at the same time, simultaneously. Example, Mr. Kim promised to buy Mr. Lee's computer for $1,000. Mr. Lee must give Mr. Kim the computer when Mr. Kim gives to Mr. Lee $1,000. $1,000 and computer must be exchanged at the same time. Exchanged simultaneously. That is the example of condition concurrent. Doctrine for base performances and discharge. most contracts are discharged by fulfilling, by completing the performances, by doing what was promised. I finished 100% my contractual obligation. That obligation is promised under the contract. If two parties to the contract complete 100% performances faithfully to the mutual goals of the contract and complete performances in good faith. In that cases, it will result in discharge of the contract for both parties. When the parties perform their obligation in good faith in order to complete the contract, this completion is referred as a discharge. What is the meaning of a completion? Completion means to fulfill all duties, 100% fulfill all obligation is defined as a completion. Completion is known as discharge because both parties have now discharged their obligation to the other party by performing the agreed upon duties. The level of performance that is expected of the promisor. In order to determine whether a promisor is discharged by performances, the judges will consider the standard of performance that is expected of the promisor. There are two types of level of performance: strict performance standard and substantial performance standard. Strict performance standard requires virtually 100% perfect contract terms. Substantial performance standard is a performance that falls very short of a complete performance in a minor respect. Strict performance standard. The performance must strictly and completely comply with the contract before other party has to perform. Example: the buyer, home buyer, prospective buyer agrees to finalize home purchase by 5 p.m. on June 6. If the prospective buyer does not cross by that time, 5 p.m., then the contract will be ended. The buyer is discharged from buying, and seller is discharged from turning over the houses to the buyer. But there may be legal remedies, legal compensation to the seller for buyer's breach. Second type of performance standard is a substantial performance standard. Substantial performance is somewhat lesser standard of a strict performance standard. Substantial performance will be applied and the duties are difficult to perform without some deviation from 100 perfection. They are very difficult to comply to the 100%. Therefore, it needs some little deviation from the 100 perfection is a substantial performance. In order to prevail in a substantial performance cases, the party trying to enforce the contract must show that she acted in good faith and his or her any little deviation from the required performance was not material, was not important. If the party substantially perform only the essential duties of the contract in a good faith effort, then the judge, the court judge, will enforce these agreements. 100% does not require. Substantial performance is required, is enough to enforce the contract. Example of this type of obligation, the most common example of this type of substantial performance obligation is a promise to construct the building. Other example includes the promise to construct the law, to promise to cultivate the crops, promise to render, to provide some type of professional service, or provide the type of personal service. Example. Mr. Kim's building company built the house for Mr. Reed. Mr. Kim met the contract terms, performed almost all of the contract terms except one minor. That is, Mr. Kim did not paint the baseboard the right shade of white. This is a minor deviation. Mr. Kim performed the substantial performances. In that cases, under the doctrine of substantial performances, Mr. Kim is discharged from the contract building the house. And Mr. D has a legal duty to pay the contract price to the Mr. Kim. But contract price minus any damages, repainting, okay, is enough. Other events of discharge of contract. Discharge by mutual consent. If neither party has fully performed, the both parties, two parties, may agree to cancel, to rescind the contract. This cancellation is known as rescission, Newton knowledge. Another Newton knowledge is the occur and satisfaction is a Newton knowledge in the contract. Under the doctrine of occur and satisfaction, one party agrees to provide a substitute performance in the future that is known as occur, and the other party promises to accept that substitute performance in discharge of existing performance obligation is a satisfaction, because the satisfaction occur and satisfaction doctrine. Another Newton knowledge is a modification. Modification is a legal substitute agreements. The parties to a contract may also discharge the obligations by replacing the original contract with a substitute agreement that is known as modifications. Another knowledge, novation. A novation is a kind of substitute agreement that involves substitution of a third party rather than on substitute promises. Substitute the person, third party persons rather than the promises. Okay? Replace only another person, not replace the promises. Okay? That is known as novation. Then the parties agrees to substitute a third party for one of the original parties to the contract. The agreement may be discharged through novation. On novation, revoke, cancel, and discharge, and avoid all of the replaced parties' obligations under the old contract. Impossibility of the performance. If contractual performance becomes impossible because the destruction of the subject matter of the contract is burned out or demolished or destructive, or one party is died, or incapacitation, Incapacitated means insane. Damage of brain. These are incapacitations. And the means of performance cannot be performed due to the uncertain event, such as the cost is very high, earthquake, etc. And the performance under the contract become illegal. Selling and buying marijuana become illegal. In that case, the contract may be subject to discharge. The contract can be cancelled. The contract also be discharged. Contractual obligation can be discharged by the operation of law. A party may be discharged from the original term of contract by operation of law if the contract has become impossible. Contract become impractical. Contract, the purpose of contract has been frustrated. In that case, the obligation can be discharged by the operation of law. Commercial impracticability. If the performance of the contract becomes extremely difficult, or the performance becomes extremely costly, performance obligation become very, very expensive, costly, due to some unforeseen future circumstances between the time of agreement and the time of performance. In the cases, the contract may be subject to be discharged. Example, unforeseen circumstances are such as the war, national war, labor strike, or crop failure, or earthquake, or hailing, tsunami, etc. may cause the performance of a contract to become impractical. In that case, the contract obligation can be discharged. Frustration of a purpose of contract is discharged if some event make it impossible to obtain this purpose of a contract, impossible to earn this goal of the contract. In that cases, the obligation can be discharged. Frustration of a purpose, contract purpose, may be used to discharge on obligations after the parties enter into a contract. Can unforeseen future event undermine the parties' principal purpose of contract for entering into a contract? Or those two parties already knew of these principal purposes or the both parties have not otherwise agreed on the party, on the contract, who bears the risk of such an occurrence. In that case, the contract can be cancelled, avoided. Frustration of purpose is a court ordered doctrine. Supreme Court held it, except the text. Okay? That is the bankruptcy court. In that case, the injured party or damaged party, even if the damaged party win the cases, the damaged party cannot collect the money, cannot collect the compensation from the dependent party under the bankruptcy court, federal bankruptcy court, or the party may be discharged from the expiration of the statute of limitations. Statute of limitation is defined as a period of time within which a person, a business can bring a lawsuit. After the statute of limitations, nobody, even if a government officer, cannot sue against anybody for any legal issues. Uniform Commercial Code, Section 725 provide that there are contract involving sale of goods. Statute of limitation for contract involved in the sale of goods is 4 years. After the 4 years, seller cannot collect the money from the client, from the customer, under the statute of limitations. Breach of contract under the implied covenant of good faith and fair dealing. Every contract includes the obligation to perform in good faith. Good faith doctrine. If promisor fails to perform, breach of contract will occur. The party that suffered the breach of contract is known as plaintiff. The damaged party is entitled to sue the breaching party in order to recover money damages. That is referred as remedies or compensations. Anticipatory breach or anticipatory repudiation is occurred when promisor indicate before the time for performance that promisor tell the promisee, I am not willing to carry out the contract. I am not able to carry out the contract. In that case, from C, the injured party has three options. Injured party can, first option, injured party can withhold its own performance and sue for damages for total breach of contract immediately. Second option, injured party wait to sue until the time for C's performance in case the other party C change his or her mind and decide to perform again. Third options, injured party waive his right to perform, cancel, agree, accept the C's breach. Types of contra remedies. The basic categories of contract remedies are three types: legal remedies, equitable remedies, restitutions. Legal remedy is referred as money damages. Equitable remedy is the judge's order. Traditional legal remedy is a recovery of monetary damages. Legal remedies include compensatory damages, nominal damage, liquidated damage, or contractual damages, and in certain circumstances, punitive damage. What does it mean? There are a lot of types of legal damages, such as compensatory damages is a legal damages, nominal damages is a legal damage, liquidated damages is a legal remedies, and contractual damages is a legal remedies, and punitive damage is also legal remedy. There are a lot of legal remedies. First type of legal remedies are compensatory damages. Compensatory damages are this damage attempt to put a non-breaching. This is a definition on the contract law. Contract code defined as a compensatory damage as blah blah. Compensatory damages is an attempt to put the non-breaching party, plaintiff party, in the same position she would have been in if the other party, the defendant party, have performed as agreed. These damages are measured in three ways: loss in value, consequential damages, and incidental damages. Three types of damages in the compensatory damages. Consequential damage. Consequential damage compensate the non-breaching party for foreseeable indirect losses not covered by compensatory damage. Example of compensatory damage is that the loss of damage can be recovered as a consequential damages if these damages are foreseeable and this damage can be proved with reasonable certainty. In that case, lost property must be recovered from the defendant. Breaching party is a consequential damage. Incidental damage instead of them to compensate for reasonable cost that is incurred in an effort to avoid future loss. Example of instant damages is out-of-pocket damages. Liquidate damages. Another type of legal damages is a liquidate damage. Liquidate damage is a damage that parties agree in advance to ahead of the time. A specific dollar amount is set forth in advance as the amount of damage in the event of a breach of a contract. A damage, this liquidated damage cannot be excessive, so as to penalize the breaching party. Liquidated damage provisions will not be enforced if some dollar amount is unreasonably, unnecessarily great in reliance to probable loss and probable injury. Another legal damage is a punitive damage. Punitive damage is designed to punish and deter similar behavior. As a general rule, punitive damages are not recoverable in a contract action. Punitive damages can be awarded, are allowed by law, by statute. There is no fraud. There is no some other independent tort. Tort means wrongdoing. There is a breach of implied covenant of good faith. In these following cases, the punitive damage can be awarded. Punitive damage is more than punitive damage amount is 5 times. More than 5 times to the ordinary damages. Equitable remedies. Equitable remedies are also available when money damages will not be adequately compensate the plaintiff. One of the type of equitable remedies is a specific performance. Specific performance is a court order. The court ordered that the breaching party, the defendant, must perform a specific act. This specific act is usually stated in a contract. This remedy is available only when subject matter of a contract, such as the house, building, rent, is sufficiently unique so that money damage are not adequate. Another type of equitable remedy is injunction. Injunction. Injunction is a court order. Court order requiring someone to do something. You do something for the plaintiff, or you refrain from doing something. You do not smoke a cigarette. This is injunction. There is 2 types of injunction: mandatory injunctions, legating injunctions. Mandatory injunction is an injunction requiring someone to do something. you do not build, your campaign do not build a high-rise building in front of plenty is the apartment. Because if you build a high-rise building, the plenty cannot see the view, beautiful view. Therefore, you do not build a high-rise building. Okay? Or you demolish some buildings for the plenty. You cannot affect your wife in certain distance is a mandatory injunction. Negative injunction is an injunction requiring someone to refrain from doing something. Okay? Defamation is another type of ethical language. When the party have imperfectly expressed their agreements, and this imperfection results in a dispute, then the judge have a power to change the private contract by rewriting by the judge to conform to the party's actual intentions. Therefore, reformation is defined as a rewritten contract by the court in order to conform to the original party's actual intention. Is a reformation. Restitution. Specific restitution requires that defendant return the exact same property, same item she or he received from the plaintiff. Substitutionary restitution requires that defendant pays the plaintiff a sum of money equal to the benefit he or she received. Restitution, restoration of the same item. Mitigation of damage. The duty to mitigate the damage. Everybody has a legal duty in a contract to decree is the damage. The duty to mitigate the damage involved is the obligations on the parties in a contract in order to take appropriate steps to avoid future incurring damages and losses. Okay, clean. We are almost done. We finished the paragraph. Clean hands doctrine. Clean hands doctrine will be applied to the contract enforcement. Clean hands doctrine requires that the party must show that he or she has no fault in the breach of the contract, and the party must show that he or she was ready and was willing to perform and able to perform and ready to perform his or her obligation. Is a required obligation under the contract. Is a clean hand doctrine. Assignment. Assignment is a transfer of a current right to the another person, to the third party. Delegation is a transfer to the current duty to the third party, to the another person. Okay? You must distinguish between the assignment and delegation. Assignment is a transfer of a current right under the contract by one party to the third person, to the third party. However, delegation is a transfer of a current duty to the third party. Is a delegation. Third party, beneficiary. Final slide. Okay. Ordinarily, the third party of the contract do not have a legal right to receive the benefit. That is a general rule. However, there is only one exception to the general rule. Is a third party beneficiary. If third party is an intended beneficiary as opposed to an incidental beneficiary. Third party is an intended beneficiary person, not an incidental beneficiary person. In that cases, a third party has a legal right to receive a benefit from contractual promises between offerer and offeree, between the two other parties. Therefore, a third party have a legal right to sue against the dependent, and third party has a legal right to sue